So the slash there, does it denote to the reader that it could be either or either one?
I don't know.
You don't know how a person would read it?
No.
But that was your attempt, or the company's attempt, to make it more transparent?
Yes.
And according to this exhibit, Mr. Stenman, who is the principal of Northwest trustee?
Object to the form.
I'm not sure I understand the question. What do you mean by principal?
Who is Northwest trustee the agent of?
Oh, Deutsche Bank National Trust Company as trustee for Morgan Stanley ABS.
Okay, but Deutsche Bank National Trust Company did not send you the referral to foreclose on Mr. Fraser, did they not?
Object to the form.
No.
Who sent the referral?
America Servicing Company?
Okay, so by this designation, do you have a separate relationship with the Security Trust and America's Servicing Company?
We're assuming that, or we're inferring from the referral that America Servicing Company is acting as or through Deutsche Bank. We're assuming that they have an agreement in place and that they're authorized to designate us as an agent for the purposes of issuing the notice of default.
Okay. But again, that is an assumption. Have you seen the agreement that you're talking about?
No.
The document that confers the authority on America Servicing to have you act as an agent for both of them?
No.
In your review of the Lucero file, did you come to an understanding that there was no foreclosure sales?
Yes.
And how did you come to that understanding?
We never issued a notice of sale.
And that resulted from you looking at your file?
Correct.
Was there any other factor that led you to believe, strike that, was there any other reason why the Lucero file did not go to sale?
They participated in mediation after the NOD was issued, and it's my understanding they came to an agreement on the loan modification.
When did you become aware of that fact?
I'm trying to remember when the closing bill instruction was issued. I don't remember the date.
Yes. Mr. Stenman, have you ever seen Exhibit 18 before coming here for your deposition?
Yes.
When did you see Exhibit 18?
I think it was provided by the Washington Department of Commerce with their referral, with their notification of the mediation to us.
Directly to Northwest?
I think so. Yeah, I think it came from them. When I reviewed the notes, I didn't see that it was sent directly to us from somebody else. And it was imaged in our mediation section of our archive. That led me to believe that the DOC provided the notice to us, along with the email notification that that mediation had been elected.
So let's talk about, we'll strike that. Let's take a lunch break, because this section is going to be a while. Okay? So come back at 1:25. All right?
Does the record reflect then that it's approximately 12:25 12:23, and we're going off the record. Centered. Time is now 1:29 p.m. and we are back on the record.
Okay. Mr. Stenman, I was asking you questions regarding Exhibit 18, and your testimony, as I recall, is that you do recognize the exhibit.
Yes.
Do you not? Okay. And I also see that on Exhibit 18, Northwest is reference.
Yes.
Does that clue you in as to how you received it?
No, I just remember there was an image of this in our archive.
How would you have received it as a referral from the Department of Commerce?
In an email.
Are there procedures established by Northwest that provide for cases being referred to mediation under the FFA?
Object to the form.
Are there what?
Procedures.
Procedures to, well, yes.
Can you describe them for me?
There's so RC, Ralph Crabtree Olson provides us with a list of servicers or beneficiaries that they represent in mediation. So when we get a notification from the Department of Commerce, we look up the case in their list to see if it's one where they represent. And if it's one where they represent, we refer that to RCO. We notify RCO of the email from the DOC. We forward it.
Okay. Where does this list of servicers that retains RCO as counsel for mediation?
They make a list available to us. It's in our network. It's like a spreadsheet.
I'm just going to interject. Don't testify about communications between you here.
Okay.
Just, I'm not saying that it's covered, but just please keep that in mind.
So I'm still not clear. You're referring to a list of servicers, and my understanding is that these servicers formally hired Ralph Crabtree, or RCO I should say, to represent them in mediation. Is that correct?
That's my understanding.
Okay. And have you personally seen this list?
Yes.
Is it in written form, in electronic form?
It's stored electronically.
Is it a list, or is it the actual agreement, if you will, by the servicers to retain RCO?
It's a list.
And it is your testimony that it is your company that looks at this list, determine which ones covered by that list, and then send over to RCO.
If they're on the list as represented by RCO, then we forward it to RCO.
All right. Have you heard of the term attorney referral or attorney network within the LPS system?
Not really within the LPS system.
Okay. Have you ever come across from any of the third-party platform that tells you that these attorneys are network attorneys, for example?
I'm familiar with the term network attorneys.
And how are you familiar, if you can explain?
I think it's in the context of what you have access to in the system. It's my understanding network attorneys have most of the processes that are in place are generic, and they all participate in those processes. And non-network attorneys would have their own processes and manage the system themselves. So they may be slightly different than the network attorney processes, if that makes sense to you.
And the network refers to the LPS or the platform?
I believe so.
All right.
That's my understanding.
Sure.
I don't know if that's your understanding of what it is.
Well, I don't have an understanding at all, and so that's why I'm asking you. So then, you surmise from looking at Exhibit 18 and knowing about this list of attorneys, is that Exhibit 18 might have come from RCO?
No, I don't think so.
Okay, it came directly from Department of Commerce to you?
Yeah, the Department of Commerce usually reaches out to the trustee first because they want to confirm number one, there's a timeliness issue. They want to make sure that the notice of sale doesn't get issued or hasn't already been issued and the 20 days expired. So they first want to pass it by the trustee to make sure that they can go ahead and accept and process the referral.
Okay.
So they need some information for the trustee before they
All right.
accept the referral from the referral source, I guess. That's how I would put it.
Then what happened next?
So if it's on the list, we would refer it to RCO. If it's not on the list, then we would notify the servicer that there's been an election for mediation. And then it'd be up to we continue to follow up with the servicer on the hold. Normally the DOC will tell us if it's not RCO and we've notified the servicer, they'll tell us if they still haven't been contacted by the servicer and told that they have representation. Sometimes we'll try to facilitate the communication, but that's all we do in that instance is try to facilitate until DOC has somebody to deal with or the mediator has somebody to deal with.
Okay. So looking at the Lucero situation specifically, can we assume from your testimony that RCO is one of the attorneys on the list?
It's my understanding, I don't know if they're, because this is 2012, I know ultimately RCO was the representing attorney for the beneficiary. But I don't know if they were on the list at the time or I don't know if we notified the servicer and then they engaged RCO. That's the part I don't know.
Okay. Did your service as trustee get suspended at that point in time? Can you tell us the next step?
Let's jump to the fourth.
So for notified of a mediation, and it's in the NOD period, or the first 20 days after the notice is recorded, we automatically put the file on hold.
And by that you mean doing nothing further?
It means we don't issue the notice of trustee sale.
Are there any other activities that you would continue to do?
We might procure the assignment and the appointment.
Why is that?
Well, if it comes out of mediation and there's no successful mediation, we don't want that to be part of the delay in getting the process started again.
And whose directive would you be taking that step?
Well, it depends on the servicer and whether or not they execute documents during a hold period. Some do, some don't. Some don't want a file that's on hold to be delayed once it's off hold. So they continue to procure documents until the hold's removed.
How about in this situation with Lucero? Did you have directives or communications from Stenman that says otherwise continue with procuring documents?
Well, the notes in the system that I reviewed would indicate that we had already requested the appointment in the assignment. So those requests were already outstanding when the mediation was elected. So they would have executed and returned them, and we don't typically hold documents for specifically assignments. They want it recorded right away. They don't want us just sitting around. If we have the appointment sometimes we'll record the appointment. We don't want to wait until we're ready to issue the notice of sale. We want to be of record when we issue the notice of sale. So the appointment should be recorded when you have it.
I'm still referring you to the Lucero file. The Exhibit 18 is dated what there?
September 3rd.
Okay. So your testimony then is that your belief is that there were documents being procured or being generated in the process prior to this date?
We would have, one of the first steps we do is request the assignment and appointment. And a lot of times we do it off the beneficiary check that we get or the notification from the title company of confirmation of the order. So it would be one of the very first things that we would do after confirmation of the title order. I could look at the timing, but I believe that those things were requested before the mediation was requested.
Let me refer you back to the notice of default for the Lucero file.
What number is that?
Exhibit number 5. And in looking at, as it relates to your testimony now, can you tell me by looking at Exhibit 5 when the document, specifically the assignment and the appointment, were ordered or put in the system as far as being generated?
Looking at this, no,
What would
it
you,
wouldn't tell me anything.
what would you need to look at in terms of?
We have an event list in our system. We track the date we request them and the date that they're received. So it'd be easy date to figure out.
What is the turnaround? If you were requesting a document to be signed, what would be the turnaround, or does it vary?
It varies. It depends on the servicer. Like I said, they may put all execution on hold during a hold, like a mediation hold. They may just not have very good turnaround time when it comes to execution of documents. We follow up every 2 weeks until the document's procured. So if we request it, our system automatically sets a 2-week follow-up. If the client's got an escalation procedure, we might follow an escalation procedure to get them to execute in the return.
I'm missing money now.
What are you missing?
Go off the record for a second. I'm missing the assignment and the appointments on Lucero.
Pause. Note that we're going off the record now for a moment. It is now 1:42. The record reflected is now 1:44, and we're back on the record.
Are we done with Exhibit 5?
Yes. Can you look at 19 for me, Mr. Stenman, and tell me if what this document is, first of all,
It's an appointment of successor trustee document.
pertaining to this particular Lucero case, correct?
Yes.
And what is the date of this document as far as the signing date, first of all?
October 3rd, 2012.
And do you recognize Exhibit 19 as a in-house form?
Yes.
And how can we tell that it is an in-house form?
The case number, our file number is listed on it, just under the appointment of successor trustee name or title of the document.
Okay. And who, according to Exhibit 19, appointed Northwest to be successor trustee?
Senlar FSB.
And Exhibit 19 refers to Senlar as being the present beneficiary. Do you see that?
Yes.
So let me ask you about the text, the language that is being used here in Exhibit 19. Do you know who drafted this language?
It would have been our language. We would have drafted it, Northwest Trustee.
Okay. And the language that is being seen here, is it a, again, is the assignment Exhibit 19 a form?
Object to the form.
Can you repeat the question, please?
My question to you is that in composing Exhibit 19, Northwest did not just write it from scratch, did it?
No, it's a form with merge fields, and we would merge much of the information that references the deed of trust into the form.
And then as far as who is the present beneficiary, how do you go about deciding that?
In the referral, we're told what name to foreclose in, and that's the name that we use for the signature line.
All right. And looking at Exhibit 19 with a signing date of 10/3/12, October 3rd, 2012, can you tell when you requested the document to be signed by someone from Senlar?
Not by the form, no.
Can you tell when you received the document back from Stenman that was signed?
Not the specific date of receipt, no. I can only infer that it was after its execution date.
Okay. Can you tell what the date of the recording of Exhibit 19?
Yes.
What date is that?
It's December 6th, 2012.
Now, who was responsible for recording Exhibit 19, Mr. Stenman?
Vonnie McGillicud's foreclosure team. She's one of my foreclosure managers.
And how do you know that?
Her name's on the document, and that would have been her portfolio.
How does she go about recording it?
She sends it to the title company that we ordered the trustee sale guarantee to. And then they have a process to take it down to the recorder's office.
By looking at the signing date, and I know you don't know when you received the document back, but when you compare the date of October 3rd, 2012 with the recording date of December 6, 2012, there's a lag of almost 2 months. Would you agree?
Yes.
Does it typically take your company 2 months to get the document to be recorded?
Object to the form.
No.
So can you account for why it took so long in this case?
No, there wasn't any note about the delay in the recording. Again, I'd have to look to see when the document was received. We would have had to have the assignment before we could send the appointment for recording. So I'd have to look at the assignment and see when it was executed as well.
But let me ask you this question first. Referring you back to Exhibit 18, if you would. Exhibit 18 is the referral to FFA mediation, correct?
Yes.
And that exhibit is dated September, the first part of September.
Yes.
So can you account for why the appointment of successor trustee was executed after the case had already been referred to mediation? Like a month after?
Can I what?
Can you explain?
No.
Okay. So in terms of timeline, you don't have any ideas why there was an appointment of successor trustee that was recorded? I'm sorry, strike that. There's no explanation for why this assignment, start that again. You don't have any explanation for why this appointment of successor trustee was signed a month after the case was referred to mediation?
Object to the form.
No.
Do you have any explanations as to why this appointment of successor trustee was recorded 2 months after the case was referred to mediation?
Object to the form.
No.
You testified that the assignment would have to be in existence before the appointment of successor trustee can be recorded.
I think I used the words received.
So explain that to me.
Well, if the beneficiary at the time was not Stenman, I wouldn't send an appointment executed by Stenman to record before an assignment into Stenman was also executed. I would want to have the assignment in my possession and the appointment, and then send them, if I have both of them together, with instructions to record the assignment first and then the appointment.
And why is that significant?
Because at the time, I was under the instruction that we had to make sure that they recorded in the correct order.
But your testimony that the significance relates to the recording dates, not the signing date?
Yes.
Okay. And what's the rationale behind that? Do you know?
Object to the form.
You understand my question. The difference between the execution date and the recording date. Why does it matter more on the recording date but not the execution date?
Object to the form.
Obviously, if I have both documents, I'm gonna send both of them to record, and I don't want to record the assignment after the appointment.
Because?
Because in the record, it would look like the person that was appointing me wasn't of record yet.
Number 21? Is it 21 or? No, 20. Okay. Mr. Stenman, you've been handed Exhibit 20. Do you recognize Exhibit 20?
Yes,
What is it?
it's an assignment of deed of trust.
Relating to Lucero file, correct?
Yes,
And is this the document that you referred to when you said you wanted the assignment to precede the appointment?
yes, I would want the assignment recorded before the appointment. Correct.
And again, limited to recording and not signing.
Yes,
What is the date of Exhibit 20 as it relates to the execution or the signing date, Mr. Stenman?
November 21st, 2012.
Okay, so when you compare 21 to 19, is it true that the assignment was executed after the appointment by the dates that they were signed?
Yes,
And can you tell me what the recording date is for Exhibit 20?
December 6th, 2012.
So when you put Exhibit 19 and 20 side by side, if you don't mind doing that for me, please. Do you agree that the recording date and time of these two documents are identical?
Yes,
Of December 6, 2012 at 14:15?
yes,
And that's what, 2:15 in the afternoon?
yes.
Do you know how that happened? Meaning, how could two documents be simultaneously recorded at the same time?
Well, I don't agree with that. They have different stamps with different numbers, and it's obvious by looking at the document stamp that one preceded the other.
But not as to their timing, correct?
No, I think that has everything to do with timing. The way that the recorder's office works, they have a stamp and it records in a sequential order. So they literally accepted the assignment for recording before they accepted the appointment for recording by the stamp. The date and the time, I think, are immaterial.
Okay. And this is the way that Exhibit 19 and 20 were recorded, according to your testimony, were intentional. The manner in which they were recorded,
The order, yes.
right?
Yes, our recording instructions would have said, record the assignment, then record the appointment.
But physically speaking, Exhibit 19 was signed before Exhibit 20. Would you agree?
Yes,
And that doesn't matter to Northwest at all in terms of when these documents were signed. Only matters to Northwest as to when they were recorded.
yes,
And the recording was controlled by Northwest as to which orders you're going to record these documents, regardless of the execution dates.
yes,
Now, I want you to look at Exhibit 19 and 20 side by side again. And I would ask you to look at the notary seal and signature there for a moment. Can you decipher for me whether the notary public in these two documents appear to be the same person?
Can I?
Yes.
I don't know that I'm qualified to compare signatures and make that statement.
Well, just tell me what her name was on each of these documents.
Nancy K. Morris?
And can you see her notary seal?
Yes,
And are they matching in terms of coming from the same state of New Jersey?
yes,
And do they match in terms of her name and her middle initial?
yes,
Do they match in terms of when her commission expires?
yes,
Do they match in terms of her residing at Ewing County, I suppose?
Yes.
And do you have an opinion as to the way her signatures or Nancy Morris' signatures as appear on these two documents, whether they are similar?
No,
You cannot, or
I don't have an opinion.
let me go to Exhibit 20 and ask you that the assignment, who executed the assignment, Mr. Stenman?
Jennifer DeBron,
Okay, and who did she do that on behalf of?
Assistant Secretary of MERS.
And Exhibit 20 is also a form by Northwest trustee, is it not?
Yes,
Again, on Exhibit 20, you would merge the information regarding the individual borrower and the case, but the text is pretty much generic to other assignments of deed of trust. Can I assume that?
Object to the form.
yes. One's prepared by us, yes.
Do you know where MERS is located? Physically?
I used to know the answer to that. I can't remember what state it is.
By looking at Exhibit 20, do you know who Jennifer Dobrin worked for at the time she signed Exhibit 20?
Sendler.
How do you know? How do you know that?
She's a regular contact with Sendler. She's on their contact lists, escalation lists.
Have you
She's a
ever
supervisor over there.
have you ever spoken with her?
Yes.
How many times have you spoken with her altogether?
I don't know, 20, 30 maybe, over the years.
Over the course of how many years, would you say?
I don't know, and she's been with them for a long time. It's been a number of years.
So in looking at Exhibit 20, where she signed as the Assistant Secretary for MERS, at the time that you prepared, I'm sorry, strike that. At the time that you received Exhibit 20 being returned from Sandlar, you did have the actual knowledge that Jennifer Dobrin worked for Sandlar.
At the time she executed this?
Yes.
Yes.
And does she continue to work for Sandlar today?
Yes.
Okay. When was the last time you spoke with her?
I was in New Jersey, when was that? In April,
What were you there for?
training.
And did you, when you were there and meeting with Ms. Dobrin, did you happen to talk about this case at all?
No.
Have you ever witnessed an original signature by Ms. Dobrin?
When you
As-
say
as a
witness, you
blue
mean watch
ink-
her sign it?
Watch her sign it or see a blue ink copy of her a blue ink original of her signature?
I don't think I have seen an original. I wouldn't normally see documents that are sent to us and sent out for recording.
I see.
That would be the team.
All right. So in terms of Exhibit 20, when it came back to Northwest from Sandlar, did it come back in electronic form?
No.
Did it come back in its physical form,
Yes.
paper form,
Yes.
in original form,
Yes.
with a blue ink signature?
Yes, we
Or
wouldn't be
black
able
ink.
to send a copy to them. Well, we would have to have the original in our possession for us to send it to recording.
Right. And where is the original of Exhibit 20 now?
It's either in a file cabinet in our office or it's been returned to Sendlar.
Can you check on that? Is it
I can check.
possible to verify that?
If it's not in a cabinet, then I would not have direct knowledge of whether we returned it to Sendlar or not. If it's not documented. I don't think it's documented that we sent the original back to Sendlar.
In your system notes, you mean?
Correct.
If you didn't send it back, it would be in the file cabinet?
It might be, I mean, once it's a record, they really don't need to be retained. If somebody needed it, they could pull a certified copy.
But that doesn't mean that your company would destroy these originals intentionally. Meaning,
I mean, they just don't need to
shredding
be
them.
retained. If it was part of the file, if they have a procedure to return it to them, If the return address, the county sends it back directly to them, there's a number of things that can happen. That's why I'm not sure where the original is.
Okay. In looking at Exhibit 20, where it says that Jennifer Dobrin signed on behalf of Mortgage Electronic Registration Systems, or MERS, do you know how she acquired the title of Assistant Secretary for MERS?
No.
Do you have any doubt that she was in fact an Assistant Secretary of MERS?
I have no reason to believe that she wasn't.
Why would you say that?
I have nothing telling me or anything presented to me that says otherwise.
Do you have any reason to doubt whether she was the person that signed Exhibit 20?
No.
Do you know Nancy K. Morris?
No.
When you were in New Jersey in April, did you come across Nancy Morris at all?
No.
Are you familiar with the process by which employees of companies other than MERS sign as Assistant Secretary of MERS?
Object to the form.
Am I familiar with the process?
With the phenomenon, I'm sorry.
How they become secretaries of MERS?
If you have the knowledge.
We used to be a secretary of MERS, so yes, I'm familiar with the process.
Do you, in fact, know whether Ms. Dobrin was laboring under a similar corporate authority as you just described?
No.
I want you to look at Exhibit 19 for me and tell me who executed Exhibit 19, the appointment of successor trustee.
Michael Blair?
Do you know Mr. Michael Blair?
No.
What capacity did he sign Exhibit 19?
As a vice president?
Do you know for a fact that he is the vice president of Senlar, or was the vice president of Senlar on the date that he signed this?
No.
Do you, if I could refer you to look at the notary oath down there on Exhibit 19. Are you looking at it, Mr. Stenman?
Yes.
Okay. When this exhibit was returned to you from Senlar, strike that. In looking at that notary oath, do you see that the space where Mr. Blair's is being certified as the person signing the document is vacant or empty?
Yes.
Blank, left blank, I should say?
Yes.
Okay. And then also, in the same paragraph by the notary public, do you agree that the space where Mr. Michael Blair would be, where his title would be specified there, it's also blank?
Yes.
Did it concern anybody at Northwest in terms of the lacking, the information that is lacking from the notary oath?
Object to the form.
I don't see anything in the notes that indicate that there was a concern.
So by looking at this today, would you have any concern?
I might ask our in-house counsel if they think it's an effective notary.
But at the time, nobody seemed to pick up on it.
It
Object
was,
to the form.
according to the notes, it wasn't a raised issue.
Do you know for a fact whether Mr. Blair, I asked you that question. In looking at Exhibit 19, Mr. Stenman, it has the legend there on the left top corner, after recording return to Bonnie McElligott. Do you see that?
Yes.
Does that denote that the original will be returned to Ms. McElligott? after recording?
If the county is in possession of the original and they're going to return it to someone other than the title company that presented it for recording, it would come back to us.
Okay. In your experience, though, the recorder office doesn't retain originals. They return them. I'm sorry, start that. They don't retain the originals, do they?
No.
And so by looking at Exhibit 19, can we safely assume that it was returned to your company?
Object to the form.
No. It could have been submitted as an electronic recording, meaning the original may have never left our office.
Okay, so if it never, maybe I misunderstood your.
You can electronically record documents in King County.
Okay,
There's some exceptions, but an appointment and an assignment are not two documents that have to be submitted as originals.
so I just want to be absolutely clear. When you testified regarding Exhibit 20, I got the impression that there was an original.
There was an original, yes.
And that is because what?
Because our procedure is not to record anything but originals.
Okay. Would that
The
hold?
act of recording could be electronic or physically sent to the county for recording.
Okay, all right, I understand. So your company wants to make sure that you have originals of 19 and 20 before you send it for recording.
Yes,
The act of recording can be electronically done,
yes,
but the originals were seen, touched by your company at some point in time.
yes.
Okay. And we were done with Exhibit 20 as to you're not sure where the original of Exhibit 20 would be, correct?
Yes.
How about Exhibit 19?
Is it this, what are you asking me? If
I'm
this
asking-
is the exact copy of what the original was?
I'm asking you whether you know the original appointment of successor trustees location.
I don't know the original's location.
Where would be the possible locations for the original of the appointment?
Object to the form.
It would probably be recycled because we wouldn't retain an original appointment once it's a record.
Recycle line.
Shredded, destroyed once it's a record.
Is that one of the practices that your company engages in, is to recycle?
For original appointments, yes.
So chances are I won't be able to find the original appointment of successor trustee Exhibit 19.
There's a good chance you would not be able to find it.
How is that different than Exhibit 20 when you were talking about?
It isn't, but, well, we treat assignments differently. We have the assignments returned to us or we retain them. And then if the servicer has a requirement to return it to them, we return it to them.
Okay. And why would there be that differential treatment, Mr. Stenman?
Because sometimes the servicer wants to retain the original in their loan file, in their custodial file. So they'll want to return. Some don't, some do.
And I asked you earlier for the reasons why these documents were recorded 2 months after the case was already referred to mediation, and your answer is you don't know.
Well, the execution date of the assignment is November 21st. If we held the appointment until we had the assignment, I could see why it didn't record until December 6th. We didn't have it in our possession until some time after November 21st.
Were they sent out at the same time to Sandler?
I'll have to look at our system notes to see what the dates were, but our procedure would be to send them at the same time.
So how would you account for them coming back at different times?
I can't account for it.
Take a look at Exhibit 21, please, Mr. Stenman, and tell me what it is.
It's a tri-party MERS agreement. For signing authority.
Okay, and so explain the tri-parties being who?
MERS Corp, Chase Home Finance, and Ralph Crabtree Olson for Northwest Trustee, so Northwest Trustee Services, Inc.
So on the language of the document where it says Ralph Crabtree Olson for Northwest Trustee Services, Inc., does that mean that Ralph Crabtree Olson or RCO was acting as Northwest lawyer? Agent? Do you know?
I don't know how to read that. It says for Northwest Trustee Services.
So let's go to the second page. I'm sorry, the third page of the exhibit, if you don't mind, where the signatures appear to be.
Okay.
In looking at the signature blocks, do you see that there's two signatures for, one for MERS Corp. Inc. and the other for Mortgage Electronic Registration System Inc. there?
Yes.
Are they two different companies?
I don't know.
And in looking at the signature block for Ralph Crabtree Olson, do you see that there?
Yes.
There's a handwritten note next to it that was added. It said for Northwest Trustee Services Inc. Do you see that?
Yes.
Okay. And does that appear to be the signature of Mr. Fennell?
Yes.
And his title in August of 7, when this document was signed, it appears to be Senior Counsel.
Yes.
That Senior Counsel for Northwest Trustee?
I'm not sure.
Okay. Does Exhibit 21, when you look at the next page, delineate the power or authority for Northwest Trustee Services, Inc. to do certain things?
It appears to, yes.
And if you go to the last page of the exhibit, you see your name there.
Yes.
Okay. Does that refresh your memory in terms of your testimony that you did sign as one of the officers for MERS?
Yes.
Okay. Do you recall when you were signing as officer for MERS, the period of time?
I think it was ceased signing several years ago. So it would be from 2007 to maybe 2010.
And do you know the reason why you stopped signing as an officer of MERS?
Well, there was a lot of stuff lying around about MERS at the time, and I think the servicers, some of the servicers decided they didn't want to extend that signing authority anymore. And then we looked at it as an organization, decided we didn't want to do it at all anymore.
Now, in 2007, when Exhibit 21 was executed, as a result of its execution, you did not receive any compensation from MERS for signing as one of their officers, did you?
No.
And you never worked for MERS?
No.
In any capacity?
Well, only through this agreement.
And you once upon a time, you remember where their office is located, but you don't today.
There's like Ocala, Florida, and then there's another one in, I can't remember. There's three addresses that I remember.
Oh, that's fine.
I don't remember them exactly.
asking you to look at Exhibit 22 now. And if you can tell me what 22 represents, I would appreciate it.
It's a limited power of attorney.
Given by whom to whom?
Bank of America. And then it's to a number of individuals all listed under the first section.
Okay. Amongst them, you were one.
Yes.
And Exhibit 22